Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw, your one-step destination to all legal developments in the country. Let us start. Starting with the updates from the Supreme Court, which today heard the Delhi Chief Minister Arvind Kejriwal's plea challenging his arrest by the Enforcement Directorate in the Delhi liquor policy case. The bench of Justices Sanjeev Khanna and Dipankar Datta today continued to hear the matter at length. Senior advocate Abhishek Manu Singhvi highlighted the discrepancies in the approach of the Enforcement Directorate towards its approvers, citing examples like that of Vijay Nair, Magunta Reddy, etc. He noted that once these individuals implicated Arvind Kejriwal, the ED did not oppose their bail applications, suggesting a bias in the proceedings. Singhvi criticized this inconsistency, labeling it as a farce in terms of the credibility of the approvers. Additionally, he questioned the necessity of arrest and underlined the need for a fair and thorough examination of the case's merits. Further, some queries were put to the Enforcement Directorate by the bench seeking explanation. The bench asked ED's counsel, Additional Solicitor General S.V. Raju, to come prepared on the next date with an answer to the 5 queries, one being related to the timing of Kejriwal's arrest. The matter is next listed on coming Friday. To read in detail the arguments made in court today, you can visit livelaw.in. The Supreme Court today continued hearing the contempt case against Patanjali Ayurved, Acharya Balkrishna and Baba Ramdev. A bench of Justices Hima Kohli and Ehsanuddin Amanullah heard the matter. The case arises out of a petition filed by the Indian Medical Association against Patanjali's advertisements attacking allopathy and making claims about curing certain diseases. On the top court's reprimand, Patanjali had assured last year in November that it would refrain from such advertisements. However, the misleading advertisements continued. As a result, the court issued contempt notice. On the last date of hearing of this matter, the bench had expressed dissatisfaction with the apology published by Patanjali in certain newspapers, particularly its size. After the court's wrap, Patanjali published another apology in the newspapers, this time giving its own name alongside that of co-founder Swami Ramdev and MD Acharya Balkrishna. The bench today observed that there was a marked improvement in the nature of the apology published by Patanjali in the newspapers. But it noted that the original copies of the same as asked had still not been filed. Appearing for Patanjali, senior advocate Mukul Rohtagi pointed out to the court that an interview was given yesterday by the president of Indian Medical Association in which he reportedly criticized the Supreme Court's observation that IMA should act regarding complaints of unethical practices by doctors. Taking note, Justice Kohli asked the senior counsel to bring the same on record. Also, let me tell you here that the manufacturing licenses of 14 products of Patanjali Ayurved Limited and its sister concern Divya Pharmacy were suspended on 15th April by Uttarakhand State Licensing Authority. This comes after the Apex Court had recently pulled up the state authority for its inaction against Patanjali and Divya Pharmacy for their illegal advertisements of these products. Coming to the case against the editor Prabir Purkayastha over alleged Chinese funding to promote anti-national propaganda through the digital portal NewsClick. The bench of Justices B.R. Gawai and Sandeep Mehta today heard Purkayasth's SLP assailing a decision of the Delhi High Court which upheld his arrest by the Delhi police. Co-accused and NewsClick Human Resources head Amit Chakrabarti had also approached the top court challenging his arrest, but he was allowed to withdraw his plea after he turned approver for the Enforcement Directorate and was granted a pardon. During today's hearing, senior advocate Kapil Sibal representing Purkayastha revealed that he was arrested on the evening of 3rd October 2023 and brought before the magistrate the following morning at 6 a.m. However, during this process, only the additional public prosecutor and legal aid counsel were present and Purkayasth's own lawyer was not informed. When Purkayastha raised objections, the investigating officer notified his counsel via telephone and the remand application was sent to the lawyer via WhatsApp around 7:07 a.m. Despite these objections being raised, the remand order was strangely recorded as being passed at 6 a.m. On being questioned on this by the bench, ASG SV Raju said that Purkayastha was produced at 6 a.m. because the police wanted to do an early search and that the trial judge had recorded the time of the remand order as 6 a.m. by mistake, which was actually the time of production and not the time of the order. But the court was not convinced. The bench was also not impressed with the ASG's argument that the subsequent remand orders will validate the first remand, even if it is assumed to be illegal. The bench clearly stated that if the first remand is found to be nullified for not informing the grounds of arrest, then the further or subsequent remand orders will also lose their basis. After hearing the arguments, the bench reserved the judgment on Purkayasth's petition challenging his arrest and remand in the case under Unlawful Activities Prevention Act. Next, let me tell you that a Delhi court has today dismissed the second regular bail pleas filed by former Deputy Chief Minister of Delhi and Aam Aadmi Party leader Manish Sisodia in the money laundering and corruption cases connected to the alleged Delhi liquor policy scam. Sisodia is presently in judicial custody in both cases. Special Judge Kaveri Baveja of Rouse Avenue Courts denied bail to Sisodia after reserving the verdict in his bail pleas earlier this month. If you recall, Sisodia was denied bail by the trial court, Delhi High Court and the Supreme Court in both ED and CBI cases. The Supreme Court had also dismissed his review petitions against the denial of bail. His curative petitions have also been dismissed. In the FIR registered by CBI, Sisodia and others have been accused of being instrumental in recommending and taking decisions regarding the 2021-22 excise policy without the approval of competent authority and with an intention to extend undue favors to the licensee post-tender. On the other hand, ED has alleged that the excise policy was implemented as part of a conspiracy to give wholesale business profit of 12% to certain private companies. The Allahabad High Court has acquitted a man who was convicted by the trial court for the murder and rape of an 11-year-old girl. The background here is that the victim's father had alleged that the accused had raped and killed his daughter, whose body was found near a wheat field hours after she had gone to fetch fodder from the field. There were signs of injuries found on her neck. The role of the accused came to picture based on information given to the parents of the deceased by the family members. The additional sessions judge Shah Jahanpur had convicted the accused and sentenced him to life imprisonment. Challenging this conviction, he moved the High Court. Before the High Court, the counsel for the accused argued that he had been falsely implicated only on account of suspicion of the parents, as there was absolutely no evidence of any kind produced by the prosecution to prove his guilt. After going through the evidence on record, which consisted of documentary and oral testimony, the court noted that none of the circumstances had been produced by the prosecution to implicate him. The court also noted that neither the father nor the mother of the deceased had seen the accused committing the offence. Hence, the bench of Justices Ashwani Kumar Mishra and Mohammad Azhar Hussain acquitted him and also termed it as unfortunate that despite there being no evidence, he had been forced to remain in jail for over 12 years. The bench also noted its inclination to make harsh observations against the investigating officer and the presiding officer, but refrained from doing so since they were not heard by the bench. The Delhi High Court today issued notice on a PIL seeking expeditious filling up of the vacant position of chairperson and members in the Delhi Commission for Protection of Child Rights, or DCPCR. The plea moved by National Child Development Council submits that the functioning of the commission has been severely affected since the tenure of its former chairperson came to an end in July last year. It adds that the Commission is a statutory watchdog of the Petitioner Council on matters of child rights and has also played a vital role in monitoring of the rights, reviewing safeguards, inquiring into violations and advising the government on policy formation. The council appearing for the Delhi government informed the court that a proposal was made for inviting the applications for the vacant post and the file was marked to the concerned minister last year in August. But the minister concerned wrote in March this year that the advertisement could not be issued since the Model Code of Conduct is in force. However, the court was also informed that the Lieutenant Governor had made an interim arrangement in the meanwhile regarding the vacant post. A division bench comprising of Acting Chief Justice Manmohan and Justice Manmeet Pritam Singh Arora issued notice and sought response of the Delhi government, DCPCR and Union government through Ministry of Women and Child Development. The matter will now be heard in August. The Jharkhand High Court bench of Justices Sujit Narayan Prasad and Arun Kumar Rai has directed the state government to expedite the constitution of a transgender welfare board, emphasizing the importance of addressing needs of the transgender community. The directive came in response to a counter-affidavit filed by the state highlighting various beneficial actions taken for the welfare of transgender individuals. However, the court noted that despite the enactment of the Transgender Persons Protection of Rights Rules of 2019, 5 years ago, the constitution of the Welfare Board remains pending. The court ordered the state to establish the Welfare Board within 2 weeks and posted the matter to 14th May. Let me tell you here, the Transgender Persons Rules of 2019 provide a framework for recognizing transgender persons, issuing identity certificates to them, and establishing welfare measures such as healthcare, education, and employment opportunities. And lastly, the Madras High Court has disposed of a plea seeking stringent action against sale of IPL tickets in the black market at higher prices and to issue directions to the authorities concerned with the MA Chidambaram Stadium to conduct the cricket matches fairly. In his plea, the petitioner had stated that since the IPL attracts fans worldwide, some anti-social elements were attempting to utilize the curiosity of the fans to watch the cricket match live in stadiums. He informed the court that they were purchasing tickets in bulk and reselling them in several ways at huge costs. He pointed out that though several norms have been fixed for selling and purchasing of tickets, the same is not implemented by the concerned authorities, which leads the black marketing mafia group to earn huge income. The bench of Chief Justice S.V. Gangapurwala and Justice Satya Narayan Prasad directed the Board of Control for Cricket in India, that is BCCI, and the Sports Development Authority of Tamil Nadu to look into the representation of the petitioner and to decide the matter on its own merits. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.